My grandmother left me her house. The little green one on Elgin Street with the crooked front step and the smell of cedar and old paperbacks that I've loved since I was 4 years old. She left it to me in her will, in writing, with her own hand, because I was the one who drove her to her chemo appointments for 18 months and stayed until the nurses made me leave. But my uncle decided that didn't matter. He had the locks changed while I was still at her funeral reception, eating squares and accepting condolences in her own living room, not knowing yet that he'd already called a locksmith. That's where this story starts. And I promise you, it doesn't end where he thought it would. My grandmother, Nana Irene, was the kind of woman who kept every receipt, every letter, every birthday card in a shoebox under her bed, organized by year. People who knew her said she was stubborn. I called it principled. She had immigrated from Portugal in the 70s with my grandfather, worked 30 years as a seamstress in a factory in Hamilton, and bought that house on Elgin Street with cash saved dollar by dollar over most of a decade. It was hers in a way that very few things ever belonged to anyone. When my grandfather died 11 years ago, it became even more hers. And somehow, more mine too, because I was the one she called when the pipes froze, when the furnace groaned, when she needed someone to sit with her and watch the 6 o'clock news. My uncle, my mother's older brother, had a different relationship with Nana Irene's house. He saw it the way a certain kind of person sees anything they didn't earn, as something that should probably belong to them by default. He lived in Mississauga in a house twice the size, drove a new pickup, and had not, as far as I could tell, spent a single night helping Nana Irene through a bad week of treatment. But he had opinions about what should happen to her estate. I found out about the locks on the Sunday after her funeral. I'd driven back to Hamilton to water her plants. She had 17 of them, African violets and spider plants mostly, and to start sorting through what needed to happen next. I was the executor of her will. I had the paperwork. I had a key on my keychain that I'd had since I was 19. The key did not work. I stood on that crooked front step for a full minute, trying the lock again and again like I was doing something wrong, like I'd somehow forgotten how to use a key. Then I called my uncle. He picked up on the third ring. He sounded like he was eating lunch. "Yeah, I had the locks redone," he said. "The old ones were shot. I was up there last week and the back door deadbolt was basically held in by rust." "You changed the locks on my grandmother's house," I said. I kept my voice very flat. I'd learned to do that when I needed to think clearly. "Without telling me, relax. It's a family property. I was looking out for it." "It's not a family property," I said. "It's my property. You were at the will reading. You know she left it to me." There was a pause, the kind of pause that tells you more than the words that follow it. "Well," he said, and I could hear the shift in his tone from casual to something harder and more deliberate. "That's actually something I wanted to talk to you about. Nana wasn't herself in those last few months. You know that. We're all a little concerned about the circumstances around Will." My stomach dropped. "What circumstances?" I said. It wasn't a question. "You were with her every day, sweetheart. You were the one taking her to her appointments. You were very involved. People get attached. Old people especially. Sometimes they make decisions that aren't really." "Don't," I said. "I'm just saying, the family thinks it might be worth having someone look at it, the family." There it was. He'd already talked to my mother, to my aunt, to whoever else he'd managed to get on his side over the week since Nana Irene died. He'd spent her funeral organizing a legal strategy. "Send me the key code or I'll have a locksmith out this afternoon and bill the estate," I said. "And don't go back to that house." He laughed, a short, dismissive sound that I can still hear clearly. "You're being dramatic. We're family." I hung up and sat in my car on Elgin Street for 20 minutes, looking at the greenhouse with its dark windows and its little concrete step, and I made a decision. I was a forensic accountant at a mid-size firm in Toronto. I dealt in numbers, in patterns, in things that didn't lie. My uncle had just made the worst possible enemy he could have made, and he didn't know it yet. The next 48 hours were cold and very efficient. I called a locksmith. presented my identification and the executed copy of the will, and had new locks installed that afternoon. I photographed everything, the interior, the new locks my uncle had put in, the faint scuff on the back door frame where someone had forced it briefly before giving up. I opened every drawer, checked every cabinet, documented what was there. Nana Irene had kept records the way I kept records. Her filing cabinet in the spare bedroom held 10 years of bank statements, organized by month, in labeled hanging folders. I sat on the floor of that spare bedroom and started reading. By the time I had to leave to catch the highway before the evening traffic, I had already found something that made my hands go still. My uncle had been my grandmother's secondary account holder on her main checking account for 6 years. She'd added him, she told me once, to help pay her property taxes and utilities when her arthritis made it hard to get to the bank. He had signing authority on the account. For the first 4 years, the transactions were exactly what they should have been. Hydro bills, property taxes, the occasional grocery run on the card she kept for him. Normal. Expected. The kind of arrangement elderly people make with family members they trust. In the 5th year, there was a new recurring transfer. $800 on the 15th of every month, moving from her checking account into an account I didn't recognize. In the 6th year, the year she got sick, it went up to $1,400. I am a forensic accountant. Patterns are what I do. And this was the clearest, coldest pattern I had ever seen in my professional life. I took photos of every statement. I drove home to Toronto and sat at my kitchen table until 2 in the morning, building a spreadsheet. When I was done, I stared at the total for a long time. Over 5 years, my uncle had transferred approximately $73,000 out of my grandmother's account. Not in one suspicious lump, not in any way that would trip a flag at the bank. In steady, quiet increments on the same date every month, while she was dealing with her health and trusting him to help her with the bills. I did not sleep well that night. I don't think I slept at all. The official letter arrived 9 days later. My uncle, represented by a lawyer named Mr. Desroches, was filing a notice of objection to my grandmother's will with the Ontario Superior Court of Justice, Estates Division. The grounds were exactly what he'd told me on the phone. Alleged undue influence, alleged diminished testamentary capacity. He was claiming that Nana Irene had not been competent to make decisions in the final year of her life, and that I had used my position as her primary caregiver to pressure her into changing her will in my favor. He was going to stand in front of a judge and say that about a woman who had beaten him at Scrabble 6 weeks before she died. The rage I felt was so clean and precise it was almost like clarity. I booked 2 days off work. I drove to Hamilton and sat in Nana Irene's spare bedroom with her filing cabinet and her shoeboxes and her decades of careful record-keeping, and I built a case. She had kept every card I'd ever sent her, every birthday, every Christmas, every just because I'd written her actual letters, long ones. When I was away at university, and she had kept those too, in a rubber-banded stack at the back of the bottom drawer, sorted chronologically. I found notes she'd left herself in her planner. Thursday, Vera picks me up at 10 for Dr. Souza. Buy milk. Call back about the arthritis group. The handwriting was clear and consistent up until 3 weeks before she died. I found the card she'd given me when I turned 30. On the inside, she'd written, in her small, precise script, "You are the one who always showed up, my love. This house has your fingerprints on every wall. I want you to have it." That wasn't undue influence. That was a woman who knew exactly what she wanted and why. I hired a lawyer, a woman named Ms. Arsenault, who ran an estate litigation practice out of a narrow office above a coffee shop on King Street West, and who had the kind of steady gaze that made you feel like she had already thought of everything you were about to say. I told her I wanted to fight the objection. I told her about the filing cabinet. I told her about the bank statements. She went very quiet when I showed her the spreadsheet. "Did you verify this against the original statements?" "I have photos of every page," I said. "I can get you the originals." And he was her secondary account holder, not power of attorney, no formal BOA. She never set one up. He just had signing authority on the checking account from when she trusted him. Arsenault sat back in her chair. She had a way of being still that reminded me of my grandmother. The kind of stillness that means someone is thinking fast. He's opened the door on her financial management and her capacity, she said, which means we can walk right through it. We're going to request full disclosure of every account your grandmother had access to, every transaction your uncle authorized, for the full duration of his signing authority. 6 years, I said. 6 years, she confirmed. And she almost smiled. He has no idea what he's just done. The mandatory mediation session happened on a rainy Tuesday in March, in a beige boardroom in a building in downtown Hamilton with a water cooler that gurgled every 4 minutes. My uncle arrived in a suit I'd never seen before. His lawyer, Mr. Desroches, was polished and practiced and spent the first 5 minutes talking about how much everyone wanted a dignified resolution for the sake of the family. My uncle didn't look at me once. My client is prepared to offer a settlement, Mr. Desroches said, folding his hands on the table. In recognition of Ms. Vera's contributions to her grandmother's care, he is willing to agree to a cash payment of $40,000 in exchange for a full release of claims on the property. $40,000. For a house on Elgin Street in Hamilton, Ontario, that would sell for close to $600,000 in the current market. For a house my grandmother had bought with 30 years of factory wages. He was offering me $40,000 to go away quietly. Ms. Arsenault didn't even open her binder. We're not here to discuss a settlement, she said. We're proceeding to trial and will be countersuing for full legal costs on the basis that this objection was filed in bad faith and is entirely without evidentiary merit. Mr. Desroches smiled the way people smile when they think they're holding more cards than they are. That's a strong position for someone whose claim depends entirely on a close personal relationship with the deceased. Our position, Ms. Arsenault said, depends on 6 years of bank records, 2 decades of correspondence, testimony from her physician and her solicitor, and a very interesting pattern of financial activity that we'll be asking the court to look at quite closely. She slid a single sheet of paper across the table. It was a summary. Dates, amounts, account numbers. The $73,000, laid out in neat columns. My uncle looked at that paper for a long time without touching it. He started. That's completely out of context. Those transfers were for her care. She had expenses. She had excellent provincial coverage, I said, and her average monthly out-of-pocket medical costs were under $60. I have her receipts. Mr. Desroches put a hand on my uncle's arm. My uncle's jaw was tight. These are serious allegations, Mr. Desroches said, but his voice had changed. Something in it had gone careful. They're not allegations yet, Ms. Arsenault said pleasantly. They're exhibits. We'll see you at trial. My uncle stood up so fast, his chair scraped back on the laminate floor. You've always thought you were better than the rest of us, he said, looking at me for the first time. Sitting there with your fancy spreadsheets. She was my mother's mother. I loved her. Then you should have shown up, I said. My voice didn't shake. You should have driven her to her appointments. You should have sat with her on the bad nights. You didn't. I did, and she knew the difference. He left without another word. Mr. Desroches followed quickly, already on his phone. What came next moved faster than I expected. Mr. Desroches, having seen the financial summary, apparently had a frank conversation with his client about the concept of criminal exposure. Within 2 weeks, he had filed a motion to withdraw. My uncle had to find new representation, and the new lawyer, younger, less polished, more nervous, immediately requested a delay in proceedings. The court denied it. In the meantime, Ms. Arsenault had filed a formal complaint with the Ontario Securities Commission about the account into which my uncle had been transferring funds. It turned out the account was a joint account. His name and his wife's name. The $73,000 had been used, as best as we could trace it, to cover a series of HELOC payments on their Mississauga property during a period when his contracting business had been struggling. He had used his elderly mother-in-law's grocery money to keep his mortgage current. I found this out on a Thursday afternoon, and I sat in my car in the parking garage under my office building for a long time, just breathing, before I could go back upstairs. The second conversation I needed to have was with my mother. She had not taken his side. Exactly. But she had not taken mine either, which in this situation amounted to this. She had stayed very quiet, very neutral, in the way she always did when she was uncomfortable with a conflict she felt she should have prevented. I understood that. I didn't have the energy to be angry about it on top of everything else. I drove to her house in Burlington on a Saturday morning. She made coffee. We sat at her kitchen table, and I showed her the bank statements. She didn't speak for a long time. He told me it was for her care, she said finally. Her voice was very small. When I asked him once a couple years ago why he was always managing her accounts, he said it was because she needed help. He said you were too far away. I drove from Toronto every 2 weeks, Mom, for 6 years. He knew that. She looked at the paper. She looked at the total. Oh, Irene, she said, just that. To her mother, not to me, and she started to cry. I reached across the table and took her hand. There wasn't anything else to do. She came to court with me. She sat in the row behind my chair, next to Nana Irene's friend from her sewing circle, who had known her for 40 years and who had submitted an affidavit about Nana Irene's sharp mind and her very clear opinions about everything from politics to the proper way to hang a curtain. My uncle sat at the other table with his new lawyer. He looked like he hadn't been sleeping. I recognized that look. The judge, a woman in her late 50s with reading glasses she took on and off throughout the proceedings, had clearly read everything in advance. She moved through Ms. Arsenault's evidence with methodical attention. The will, drawn up by a solicitor with 30 years of practice who testified to Nana Irene's complete competence. Her physician, who described her as cognitively sharp and medically informed until very close to the end. The correspondence, my letters, her cards, her planner notes, which painted a portrait not of a confused old woman, but of someone who knew exactly who showed up for her and who didn't. Then Miss Arsenault moved to the financial records. My uncle's lawyer objected that this was a probate hearing, not a criminal proceeding. The judge looked at him over her reading glasses. The petitioner raised the question of his aunt's financial vulnerability, she said. The court is entitled to examine who was actually managing her finances and to what end. Objection overruled. Please continue. For the next hour, Ms. Arsenault walked through the full 6 years. The recurring transfers, the account structure, the HELOC payments, the timeline that showed clearly that the transfers increased in the same months that my uncle's contracting business had cash flow problems. A fact we had established through his own business filings, which were public record. My uncle did not take the stand. His lawyer advised him not to, which, as Ms. Arsenault had predicted, told the court most of what it needed to know. When the judge's ruling came, it was complete. The notice of objection was dismissed. The will was confirmed as valid. The house on Elgin Street was mine. She awarded me full legal costs to be paid by my uncle and an additional $22,000 in punitive damages for the bad faith nature of the filing. Then she took off her reading glasses and set them on the bench. I want to address the financial records directly, she said. What this court has reviewed today is consistent with a pattern of financial elder abuse under Ontario's Elder Abuse Prevention Act, sustained over multiple years, and bear no relationship to any documented care expenses. She looked at my uncle. I am referring this matter to the Ontario Provincial Police Financial Crimes Unit for further investigation. If you have counsel, I would strongly recommend you contact them immediately. The gavel, the scrape of chairs, my uncle left without looking at me. His lawyer walked very close behind him, already talking quietly into his ear. My mother was crying again, quietly, in the row behind me. I turned around and she put her arms around me and held on, and I let her, because she was my mother, and she had lost her own mother 6 weeks ago, and none of this was the grief she deserved. Outside on the courthouse steps in the thin March sunlight, Miss Arsenault shook my hand. "What happens next with the police investigation?" I asked. "That's no longer in your hands," she said. "You've done everything you needed to do." The charges came 4 months later. Financial exploitation of a vulnerable adult. Breach of fiduciary duty. The amounts involved were large enough that the Crown decided to proceed. His wife, who had benefited from the transfers without, as far as the investigation could determine, knowing their source, was not charged, but she was required to cooperate. I didn't go to his trial. I had said everything I needed to say in the courtroom that mattered. What I did was this. I went back to Elgin Street on a Saturday in early May, when the tulips Nana Irene had planted along the front walk were just starting to come up, red and yellow, the same ones she'd planted every fall for 30 years, always from bulbs she ordered from a catalog. I sat on the crooked front step with a cup of tea and looked at the street she'd looked at for most of her adult life. The house needed some work. The eaves needed clearing. The back fence had a post that had been leaning since last winter. I made a list, the way she always made lists, neat and practical, things to do in the order they needed doing. I didn't sell the house. People asked me if I was going to. It would have been a very significant amount of money, and I understood why they asked. But that wasn't what she gave it to me for. She gave it to me because I was the one who showed up, and because she trusted me to take care of something she had built slowly over a lifetime with her own hands. Selling it would have been the one thing I could have done that she would not have understood. So if I kept it, I drive out from Toronto on weekends. I have been slowly repainting the rooms. Not some trendy color I found on social media, but the same warm cream she always used, because it makes the light in the afternoons look exactly the way it did when I was small. I have her spider plants in the front window. I have her shoeboxes in the filing cabinet. My mother comes sometimes. We have tea on the crooked step. She talks about Nana Irene the way you talk about someone you miss so much it still surprises you, even months later. I listen. I let her talk. The legal fees and the punitive damages together covered the cost of the roof repairs and then some. The house is in good shape. The tulips came back this spring without any help from me, the way they always did, because some things that are planted with enough care simply keep going. My grandmother knew what she was doing when she left me this house. She knew who would fight for it. She knew who would sit on the front step with tea and watch the street and not sell it the minute the market was good. She had always known which of us saw things clearly, and she had left me the tools to prove it, the letters, the records, the careful life she had lived. All of it, there when I needed it. The file is closed. The tulips are red and yellow on the front walk. I am sitting in her chair, at her table, in the house she built, and I am finally, after everything, at peace.